Federal agencies or state agencies. I mean, that's not the goal of it. The goal is to take bad guys off the street, and that's what we do.
The Second Amendment Preservation Act, or what many know it as SAPA, was ruled unconstitutional by a federal judge.
The state's highest court overturned a lower court ruling that threw out a challenge to the Second Amendment Preservation Act.
We're going to look at all things. I think we'll look at the legislators, we'll look at our legal general counsels looking at things like that.
Tonight, a bipartisan group of senators say they've reached a framework on gun legislation.
Missouri gun law now considered unconstitutional, but a federal judge's ruling today is likely not the end of
State's Second Amendment sanctuary law, which forbids state agents from enforcing federal laws that violate the Second Amendment, was recently rejected by the Supreme Court. The Eighth Circuit will now hear this case and determine whether or not this law is valid, a decision that will have a significant impact on the entire country. Missouri's case and the SB 8 parallel. This Missouri law, known as the Second Amendment Preservation Act, aims to assert state sovereignty over federal arm regulations. Under this law, Missouri interprets the Second Amendment and restricts support for and enforcement of federal laws it deems inconsistent. The law allows individuals to sue state officials who assist in enforcing federal arm regulations perceived to violate the Second Amendment. The federal government challenged this law, arguing its constitutionality based on its interpretation of the Second Amendment. A district court sided with the federal government, striking down the Missouri law. The structure of Missouri's law, similar to Texas's SB 8, shifts enforcement from state entities to private individuals, making it difficult to challenge the law in its entirety. Like SB 8, Missouri's law attempts to evade traditional legal challenges by dispersing enforcement among private citizens rather than state actors. The comparison to Texas's abortion law, particularly in light of the recent Supreme Court decision regarding SB 8, provides context for understanding the legal strategy and implications of Missouri's Second Amendment sanctuary law.
Missouri gun law now considered unconstitutional, but a federal judge's ruling today is likely not the end of.
Says one of Missouri's gun laws is unconstitutional and has voided it.
In the U.S. Supreme Court to revive a controversial gun law called the Second Amendment Preservation Act.
The Second Amendment Preservation Act, or what many know it as SAPA, was ruled unconstitutional by a federal judge.
The legal landscape surrounding these laws reflects ongoing debates over states' rights, federalism, and constitutional interpretation. Legal battles over state laws. In examining the enforcement mechanisms of Missouri's Second Amendment Preservation Act and Texas's SB 8, it becomes evident that the laws rely on private individuals rather than state entities for enforcement. This setup complicates legal challenges, as injunctions must be sought against each individual bringing a civil suit, rather than against the state itself. The legal strategy employed in Missouri's law mirrors that of SB 8, which was designed to evade traditional legal challenges by dispersing enforcement among private citizens. In the case of SB 8, this approach made it difficult to seek pre-enforcement injunctions against individuals enforcing the law. The legal challenge to Missouri's law reached the United States Supreme Court, where an 8-1 decision denied the state's request for a stay on the lower court's decision to strike down the law. Justice Thomas was the sole dissenting voice in favor of granting the stay. In their statements, Justices Gorsuch and Alito referenced the precedent set by the Whole Women's Health case, emphasizing that injunctions should only apply to state entities and officials, not private parties. They cautioned against injunctions that would attempt to bind private parties not involved in the lawsuit itself. Following the Supreme Court's decision, the case moved forward to the Eighth Circuit Court of Appeals, which expedited arguments. Missouri's representatives argued that the lawsuit brought by the federal government lacked a proper defendant, as the law only allows private individuals to enforce it. The federal government, on the other hand, contended that the statute does contain enforcement components involving state officers and agents. They argued that certain sections of the statute impose a duty on state officials to enforce it.
It comes on the same day that more than 100 people gathered at the state capitol to speak out against gun laws in Missouri.
We're talking about the Second Amendment Preservation Act, often referred to as SAPA, passed in 2021. It may
Federal agencies or state agencies. I mean, that's not the goal of it. The goal is to take bad guys off the street, and that's what we do.
Enforcement in Missouri are unsure of how that new law, also known as the Second Amendment Preservation Act, will affect their departments.
Throughout the arguments, Missouri invoked the principles established in Prince versus United States, asserting the state's authority to withhold funding and refuse to enforce constitutional laws. They emphasized that their law operates within these principles. Ultimately, the arguments highlighted the tension between state sovereignty and federal authority, with Missouri defending its right to interpret and enforce laws within its jurisdiction. The case represents a significant legal battle over the balance of power between state and federal governments. Analyzing the Eighth Circuit Court. Listening to the oral arguments presented in the Eighth Circuit Court of Appeals regarding Missouri's Second Amendment Preservation Act, it seems likely that the judges on the merits panel will lean towards siding with the federal government, perhaps in a 2-to-1 decision. While there may be some considerations about standing that could sway the outcome, my general impression is that the majority of the judges will align with the Biden administration's position. The significance of this decision extends beyond Missouri, as it has implications for other states with similar laws or those considering implementing comparable legislation. Additionally, it affects counties and cities that have enacted their own ordinances aimed at preserving Second Amendment rights, akin to Missouri's law. At the heart of this legal battle lies the interpretation of state sovereignty in relation to federal authority. Missouri's Second Amendment Preservation Act asserts the state's autonomy in interpreting and enforcing laws related to armed rights, utilizing principles outlined in Prince versus United States. By withholding funding and resources, Missouri seeks to defy federal regulations it deems inconsistent with the Second Amendment. However, the federal government challenges the constitutionality of Missouri's law, arguing that it misinterprets the Second Amendment and undermines federal authority.
To only support the Second Amendment on its face, declaring as invalid all federal laws that infringe on the right to bear arms.
People walked the Missouri Capitol grounds asking lawmakers for more common sense gun laws.
The state's highest court overturned a lower court ruling that threw out a challenge to the Second Amendment Preservation Act.
Tonight, a bipartisan group of senators say they've reached a framework on gun legislation.
Conversely, the federal government asserted that certain provisions within Missouri's law do involve state officers and agents in enforcement, thereby justifying their legal challenge. They argued that allowing states to unilaterally interpret federal laws could lead to inconsistencies and undermine the supremacy of federal statutes. The judges on the Eighth Circuit Court of Appeals must weigh these arguments carefully, considering the balance of power between state and federal governments. While Missouri seeks to assert its autonomy in matters of arms regulation, the federal government seeks to uphold the supremacy of federal law and ensure uniformity across states. Ultimately, the court's decision will set a precedent for similar laws in other states, and the extent to which states can resist federal regulations they perceive as unconstitutional. It will also clarify the roles and responsibilities of state and federal entities in enforcing laws related to constitutional rights. Reinstating Missouri Second Amendment law. The Supreme Court refused a request by Missouri to reinstate a state law that bars police officers from enforcing federal restrictions on the sale and ownership of arms that the state believes violate the Second Amendment. A federal judge ruled earlier this year that the state law is itself unconstitutional and blocked the state from enforcing the law. In an unsigned order, the justices left that decision in place while the state's appeal continued in the lower courts. Justice Clarence Thomas indicated that he would have granted Missouri's request, while two of his colleagues, Justices Samuel Alito and Neil Gorsuch, wrote separately to clarify their understanding of the scope of the lower court's order. Missouri Governor Mike Parson signed the law at the center of the case, known as the Second Amendment Preservation Act, in 2021. The law prohibits local law enforcement officials from enforcing federal arms laws that the state believes are unconstitutional, including federal laws that govern the registration of some arms, impose limits on who can sell arms, and impose some limits on who can own an arm. For example, the blanket ban on possession of an arm by individuals convicted of a felony. The law imposes fines of $50,000 for violations of that ban. In February 2022, the federal government sued Missouri, seeking to block the state from enforcing the law. Brian Boynton, the head of the Justice Department's Civil Division, said in a statement that states cannot simply declare federal laws invalid.
Those rights come from God, not man. And so if the General Assembly wants to expand upon those rights, they're entitled to do so.
Situations where you have state laws and federal laws sort of colliding. We hear about the supremacy clause.
We're going to look at all things. I think we'll look at the legislators, we'll look at our legal general counsels looking at things like that.
The Missouri law, Boynton indicated, makes federal arms laws difficult and strains the important law enforcement partnerships that help keep violent criminals off the street. In March of this year, U.S. District Judge Brian Wimes ruled that the law is unconstitutional because it violates the Constitution's supremacy clause, which makes clear that state laws cannot invalidate federal laws, and that federal laws trump any inconsistent state laws. Wimes barred Missouri from enforcing the law. On September 29, the U.S. Court of Appeals for the Eighth Circuit declined to put Wimes' order on hold, preventing Missouri from enforcing the law while it appealed his decision. Missouri came to the Supreme Court a few days later, asking the justices to intervene. Missouri Solicitor General Joshua Devine depicted the dispute as a disagreement about the correct interpretation of the Second Amendment. Because the Missouri legislature believes that some federal laws regulating arms are unconstitutional, he explained, it barred state and local law enforcement agencies from helping federal officials to enforce those laws. Missouri Supreme Court has rejected a district court's order to strike down a Texas law banning abortions. The state argued that courts can bar specific officials from acting, but cannot block the laws at the heart of the challenges. The U.S. does not have a legal right to sue, known as standing, because it has not been injured by the state's decision not to provide resources to enforce federal laws. U.S. Solicitor General Elizabeth Prelogar urged the court to deny the state's request, calling the law an unconstitutional attempt to nullify federal law. The court turned down Missouri's request, and Justices Thomas and Gorsuch did not provide any explanation for their decision. Gorsuch explained that federal courts cannot issue an order that would bar enforcement of the law itself or private parties not part of the litigation. The state's request was deemed unconstitutional by the U.S. Supreme Court. That's all for this video, folks. See you next time.